Finlayson.
As is always the case with that member, that was a very useful contribution. And it seems that that is the first time that we've heard from the Labour Party in this place an acknowledgement that the 2004 Act is discriminatory, because what it did was it unilaterally extinguished the uninvestigated customary property rights of Maori, and more importantly, in the early 21st century denied a significant section of the population the right of access to the courts. And that was a very important admission on the part of that honourable member. And it seems to me the issues of principle, and I'm looking forward to the debate in the Committee of the Whole, because he raises some very important issues, is do you codify or do you simply send it back to the courts and enable the courts to work it out? And I think that's a very important question, and it's a very fair question, and I thank the member for raising it. My preference is to go along with the submission of Dr Michael Cullen on behalf of the Labour Party to the review panel, which Mrs Turia mentioned was set up in March 2009. And I quote for the member's benefit exactly what Dr Cullen said. Statutory codification of the common law tests should be retained, subject to the panel making any suggestions for changes. To wait upon protracted legal arguments developing a New Zealand jurisprudence in this respect would defeat the purpose of what many are seeking, both certainty and equity. And in a fair and objective manner, I have taken the comments made by the Court of Appeal in the Ngāti Apa decision, looked at international developments, and as I was urged to do by the UN Special Rapporteur, James Anaya, who put that in his report, particularly by reference to Canada, and come up with tests that I believe create an enduring situation in this area. And I use as an example something Dr Cullen also mentioned: provision should be made for recognition of customary transfer for some period after 1840, and that's exactly what we've picked up to recognise, for example, the situation with Ngāti Porou ki Hauraki. And then the second major issue of principle that the honourable member has raised, and we can go into this in some detail in the Select Committee, concerns the issue of agreements, and an SOP which I will introduce will address directly the concern that many people have in good faith raised about agreements. It's been expressed sometimes somewhat pejoratively as shoddy deals done with Maori and ministers. But I refer the honourable member to his order paper of today, particularly item 46, which deals with Ngārohe Moana o Ngāti Hapu o Ngāti Porou bill for the benefit of Mr Horomia. That bill gives effect to an agreement that was entered into between representatives of Mr Horomia's iwi and Dr Cullen in late 2008. And in a spirit of great generosity, that iwi has agreed that it could languish, as it were, at the bottom of the order paper until this review was completed. So these are important matters of principle, and I'm certainly looking forward to debating those matters with the member, for whom I have great respect, in the course of the committee stages. Because today what we're doing is taking another step towards repealing the 2004 Act and replacing it with a non-discriminatory regime, a regime that recognises and protects the rights of all New Zealanders in the area between the high water mark at mean high water spring tides and to the extent of the territorial sea. And I say to Mr Boscawen that his question this afternoon was fundamentally flawed. Don't confuse the marine and coastal area with beaches, as he always seems to do, because they're two different things. The space is going to be known as the New Zealand Common Marine and Coastal Area. It acknowledges it's an area where all New Zealanders have interests. And as the previous government did, and I acknowledge they were right to do so, there are private interests around the coastline. There are 12,500 private titles, general land owned by Pākehā, general land owned by Maori, and also Maori customary land. We're not going to interfere with those rights because, contrary to what the Greens would suggest, two wrongs don't make a right, and you have to respect those private property interests. What this area does is recognise the importance to New Zealand is of the common marine and coastal area, and no one can enter on it for the purposes set out in Clause 27 and then charge for it. So charging is not on. So, Mr. Speaker, the interests of Māori are recognised in three ways. It recognises the long-standing connection of all iwi, hapu and whanau to a specific part of the marine and coastal area, and that part of the relief builds on what the Labour Party did in 2000 when it passed the Hauraki Marine Reserve Act. It builds on that concept of the mana tuku iho, and that was done particularly to try and incorporate some of the concerns of Mr. Harawera, who told a newspaper reporter he hadn't read the bill. So what the award does is it allows iwi, hapu and whanau to take part in statutory conservation processes within the area, including the establishment of marine reserves and conservation areas and the management of stranded whales. And what it does effectively is formalise existing practice, because the Department of Conservation has normally been very good in dealing with the right people on these issues. Secondly, customary rights exercised since 1840 in accordance with tikanga Māori can be formally recognised, and the future exercise of those rights can be protected. And finally, as Mrs. Turia said, there will be the right to go to court to seek to establish customary title. The bill is the result of extensive consultation. That consultation started the day I became Attorney-General. The debate within Māoridom has gone on for much longer. As Mrs. Turia said, essentially it's gone on since 2003, and it went on because it started at the top of the South Island, where if there had been a different approach, the issue would never have even gone to court, and I acknowledge that. So I referred to the progress, and Mrs. Turi has set it out very carefully, the progress of the reform from the time of setting up the review panel under Justice Jury and his team, and then the extensive consultations with a wide variety of interests, from local government to recreational to commercial to customary interests, to try and see if we could obtain a good result. The bill was introduced in September 2010. It had 6 months of hearing in the Select Committee. I note with interest that the Foreshore and Seabed Bill had 3 months before the Select Committee. The report came back to the House on 4 November 2004. The second reading, committee stages and third reading were on one day, one sitting day, 16 November 2004. So no one can say that we have been doing what the previous government did. And the submissions have been taken into account. But I do say this to the Honourable Member because he raises an important point. Bona fide, decent submissions were carefully considered and have been incorporated by me. But I want to read into Hansard several excerpts of material I've received which are representative of some of the views expressed by some. I've been told that Māori should feel lucky not to have been wiped off the planet. One correspondent told me but because they want the right to go to court, Māori are covetous and are in breach of the Ten Commandments. The letter that best sums up so much of the unfortunate tone of some of the correspondence and some of the submissions is this response. Nowhere else in the world is a small section of the population encouraged to have ideas of ownership and possession above their station. No member of this House would endorse that kind of garbage. It is totally inappropriate, and I am not going to entertain that kind of submission. And that is why I say to the Honourable Mr. Parker, it's a very dangerous proposition when you determine the quality of submissions by the bulk of them. And we have looked very carefully at the Select. Well, as has been said, he had ample opportunity. The report was available on the Friday. So the supplementary order paper is going to address a number of issues which should alleviate people's concerns. I want to thank my colleagues in the Maori Party for taking part in this longer conversation since November 2008. This is a good faith endeavour to create an enduring solution, and it's very interesting that when one hears from the lead speaker for the Labour Party, one sees what the issues are, and basically it boils down to the issues of agreements and to the issue of codification versus non-codification. I'm in Dr. Cullen's camp. Certainty and equity require codification. So let's have that principal debate in the Committee of the Whole, and then we can move on.